Sorry, what was the year again?
August 1987.
Action. In August 1987, Mr. George Balmoan was gassed by carbon monoxide produced by a gasworks that was owned by British Gas. Mr. Balmoan then sued British Gas and was advised to settle out of court and then to sue his solicitors for negligence. So if you'd like to take the story on from there, Mr. Balmoan.
Well, in Cyrus versus Moore, Lord Denning, Master of the Rolls, says that since the year 1613, if not before, it has been accepted in our law that no action is maintainable against a judge for anything said or done by him in exercise of a jurisdiction which belongs to him. The words which he speaks are protected by an absolute privilege. The order which he gives and the sentences which he imposes cannot be made the subject of civil proceedings against him, no matter that the judge was under some gross error or ignorance, or was actuated by envy, hatred, and malice, and all uncharitableness. He is not liable to action. My problem is that Lord Justices Evans and Brooke decided my problem, that is, appeal from Hastings, and gave order 3161/99, August 1999, against Hastings solicitors Jolyon Holden, who was represented by the Deputy Chairman of the Law Society, Mr. the QC Barrister Acton Davis. They refused to accept the judgment of the Supreme Court of Appeal in London. I was astonished that the Deputy Chairman of the Law Society, the QC Barrister Acton Davis, went back to Hastings QC Judge Michael Kennedy, who restarted the case by the back door and 100% ignored the decision of the Lord Justices. They reserved the case to himself and eventually reversed 100%, going back not only to his March 1998 decision, but broke up a one story into 2 or 3 separate claims. I never applied to him to do that, as he lied in a back door trials, as if 3161/99 does not exist. But also took a separate text out of context and judged in 2002 that Solicitor Holden was 100% correct, and thus sent me into massive bankruptcy to this day. Since 1999, I have been ill. Additional medical reports from National Health Service hospitals are available, and could not take the problem which the two QCs had made exceedingly complex and ran into almost a dozen liver files, and into worse complexity after local judge QC, Judge Michael Kennedy, reserved it to himself, no doubt by arrangement with the Law Society Deputy Chairman, the QC, Barrister Acton Davis et al. It had become an exceedingly complex situation. I am acting in person because I am the only one who knows the case. I am 100% happy with Lord Justices Evans and Brooke judgment of May 1999 and their order 3161/99. But both QCs et al. Confused me very well, and I do not think that they could really overrule the Lord Justices of London. I am sorry, I have been ill and frequently hemorrhaging, and a new additional health problem in addition to the poisoning of my chest due to the gas poisoning which went into my lungs, and also very many people in my area here had been ill, and several of them had died also. My GP did excellent medical science, and the National Health Service in Guy's Hospital and another big hospital in London. However, I am sometimes 50% better and sometimes not in good condition at all. I could not take the work of the two QCs back to Lord Justices Evans and Brooke, as they said in paragraph 6, page 2, in 3161/99, partly because they were experts. I mean, the two QCs are expert in manipulation, but perhaps I will write and send a complaint to Lord Justices Evans and Brooke. However, it is 5 years now, and I still have very little time left on the Statute of Limitations Act 1980, Chapter 32, I have 2 or 3 months left. I am not quite sure whether I am correct or not, but I have failed completely to find a solicitor in all Sussex and many parts of London, but all the lawyers in Sussex East and West and the accountants refused to help. This is a closed shop indeed. Is that enough?
When you're ready, yeah. Is that enough? Yeah,
Yes.
that's fine. Yeah.